FINRA's proposed Rule 3290 is no longer theoretical. It's been formally filed with the SEC, and firms should treat it as a near-final blueprint. Last year, FINRA proposed a major overhaul of how broker-dealers supervise outside business activities, OBAs, and private securities transactions, PSTs. Now that proposal is moving through the formal approval process. If adopted, Rule 3290 would eliminate Rules 3270 and 3280 and replace them with one unified framework. The goal is simplification. Instead of managing two overlapping regimes for OBAs and PSTs, firms would operate under a single notice, review, approval, and supervision model. But this is more than housekeeping. The biggest shift is focus. Historically, OBA reporting has cast a very wide net, capturing nearly any outside activity, even low-risk side jobs unrelated to financial services. Rule 3290 narrows the lens. Going forward, the trigger is whether an activity is investment-related. That means activities involving securities, digital assets, real estate investments, insurance products, commodities, or similar financial products. However, non-financial side businesses generally fall outside the rule's scope. This is a move toward risk alignment. FINRA is signaling that supervision should follow investor risk, not simply outside employment. There's also important clarification for dual registrants. If an associated person works with an unaffiliated registered investment advisor, that activity is treated as an outside business activity, not a private securities transaction, unless there is transaction-based compensation involved. FINRA made clear that transaction-based compensation means commissions, placement fees, or similar payments tied to a securities transaction. Advisory fees alone do not trigger the heightened PST framework. Several exclusions remain intact, including activities conducted on behalf of the firm or its affiliates and immediate family transactions without selling compensation. Certain personal investments already governed by other FINRA rules are also excluded. The overall message is consistent. Avoid duplicative regulation where other supervisory structures already apply. What has not changed is supervision where risk exists. If an associated person engages in investment-related activity involving securities transactions for compensation, firms must supervise that activity and maintain appropriate records. Consolidation does not mean relaxed oversight. There is one practical wrinkle. While Rule 3290 narrows firm review to investment-related activities, Form U4 still requires disclosure of all outside business activities, and unless Form U4 is amended, firms will continue reporting more broadly than the new rule requires for supervision. Rule 3290 does not represent a policy reversal. It confirms FINRA's commitment to consolidation and risk-based supervision. FINRA filed the proposal with the SEC in January 2026, and it was published in the Federal Register in early February. Approval could come later this year, subject to the standard review process. Firms should assume this framework is moving forward. Now is the time to prepare. Review your current OBA and PST workflows. Revisit classification standards. Begin drafting updates to written supervisory procedures, and update forms and train supervisors on the investment-related framework. Firms that begin planning now will be better positioned when the rule becomes effective. Need to stay current on regulatory updates and compliance trends? Subscribe and check the link in the description to sign up for our free regulatory alerts. At LeGaye Law, we make regulations make sense. Thanks for watching.